Good morning and welcome to SentencingStats.com. It is November 6, 2017, and I am Mark Allenbaugh. Today's episode, we are responding to a helpful viewer's comments, pointing out an error I had made in calculating Manafort's statutory maximum penalty. And also the same reader pointed out to me that the government's guidelines calculations are a lot more helpful to Manafort than my calculations or my estimates. So I wanted to go through those quickly. The first thing, when I was calculating the statutory maximum penalty last week, I had indicated that his sentence, Manafort's statutory maximum penalty, was 65 years, when in fact it's 80 years. I had made a mistake when putting together this table. 18 U.S.C. 1956, which is your money laundering charge, carries a 20-year statutory maximum. I know that, but I had written 5 years in here and didn't catch that. So at any rate, the helpful viewer had pointed this out, and indeed he's correct. He or she, I'm not sure, is correct that it is a 20-year statutory maximum. So he's facing 80 years as opposed to 65. That doesn't change the guidelines per se. That has really no effect on the guidelines, at least in this case. My original guidelines calculation, I had come out with a final offense level of 39. That's the way I calculated it. And as I indicated, there were two calculations in here that were very aggressive. One was this national security enhancement, a 6-level enhancement for a money laundering offense that involves some aspect of national security. That is rarely applied. It was applied only 3 times last year in all money laundering cases in fiscal year 2016, or 0.3% of the time. So that I can certainly see the government not pursuing in this case, although, again, the reason why I put that in there is there seems to be, by all indications, that this did implicate, or this the offense conduct did implicate issues involving national security. Certainly, the chief judge for the District of Columbia had indicated as such in a memorandum that she posted, that was posted, I should say, last week on the court's website, and that concerned whether or not the government could assert the crime fraud exception to the attorney-client privilege to get Manafort's attorney to testify against him in front of the grand jury. She, in fact, said that the government could compel Manafort's attorney to testify against him, which she did, the attorney did, and that ultimately, as we know, led to the indictment. At any rate, so the national security, that's pretty aggressive, and the leadership role, not quite as aggressive. I pegged him at a 4 under the role in the offense enhancements. As we know, it's either the amount of the number of, if you will, co-conspirators or other criminally culpable actors. To get a leadership role, you need 5 or more to be involved, or this is the catch-all where you don't need 5 or more, otherwise extensive conduct. And it seems to me that at least as alleged in the indictment and in other documents, other filings in the cases, and press releases or press stories as well, this conduct here is very extensive. So at any rate, this is my estimation. What I think an aggressive probation officer may calculate his guidelines to be in the PSR, and ultimately, as we know, it's going to be up to the judge to do the calculation. But in a document that was finally made available on Pacer, it took a few days for all the filings in Manafort's case to make it onto Pacer. They're up there now. And a document that was pertaining to some bail issues that the government had filed with the court, they had set forth their estimate of Manafort's guidelines calculations, which were consistent with mine, except for, as noted here in red, they did not give him a +6 for national security, and they're only giving him a +2 for leadership role. But everything else was the same as what I had estimated to be, what I estimated his guidelines calculations to be. So lucky for Manafort, I'm not his probation officer, and but nonetheless, as we're going to see, I'm going to in this episode, I'm redoing the statistical analyses I did based upon the government's lower guidelines calculation. It's still not helpful to him. He's still looking at a de facto life sentence. So let's see if there's a way for him to, if there's hope at the end, or light at the end of the tunnel, at least statistically speaking. So at an offense level 39, which is what I had him pegged at, his sentencing range was 262 to 327 months. Now it's only, I say that in scare quotes, 108 to 135 months. Again, that's assuming that the government ultimately goes that route in any plea negotiation. The government does not need to set forth its guidelines calculation in any plea agreement. Sometimes the government does, sometimes it doesn't. And it also depends on the type of plea. The government can set forth its guidelines calculation, and the defendant can agree to it. But if the plea agreement is what's called a Rule 11 C1B plea, B as in boy, the court is not bound to that calculation and can ignore it, essentially, accept the plea, but still come up with its own calculation. And the court, of course, will be guided by the probation office. If it's a Rule 11 C1C, C as in Charlie plea, then the court, if it accepts the plea agreement, would be bound to that guideline calculation, or whatever the stipulated sentence is in there. I have seen plea agreements that don't even have guidelines calculations. It just says 20 years, we all agree on it, that's the C plea. And if the court accepts that, the court must impose that particular sentence. At any rate, it's very early in the case, as we know, but I'm going to go ahead and do my analysis here on a 31, and let's see where that gets us. And just remember, at an offense level 39, what we had found in our data last week was that there were 91 cases with an offense level 39 criminal history 1 who had pled guilty, sentenced under 2S 1.1, which is that's the money laundering guideline, and the government, of course, agrees with me, or at least my analysis is very consistent with the government's. That will be 2S 1.1. That is the lead guideline here. So we saw the statistics revealed this: 166-month sentence was the average, 180 was the median, still very high. And we had gone through. We looked at the average sentences, noticed that they've come down over the last few years, even though that they're higher than they were back in 2006. We noted that the rate of judge-initiated downward variances was about 23% of the time, and when judges did vary, they went down 74 months on average. But again, that doesn't really help one out all that much when you're looking at a 262-month bottom of the guideline range. So, and we also, I didn't add it in here, but we also did look at departures for cooperation. That's what I'm going to do here in a minute. So let's cut to the chase here. So here is our case summary box. And when you walk through SentencingStats.com, and I encourage you to do it, it's free right now. We're in our beta stage. But you can walk through and do all sorts of scenarios and see where the data takes you and help with your analysis. So here I reran it under an offense level, as we see up here, 31. Again, under 2S 1.1 for money laundering. The guideline range for offense level 31, criminal history 1, is 108 to 135 months. Our 24-month target sentence, I just threw that out there arbitrarily as a quote-unquote reasonable sentence that an attorney may want to ask for in this case. A 24-month sentence is greater than 9.4% of all sentences in this group of 352 cases that we were able to identify. So 24-month sentence, not surprisingly, still on the low side, but not an insignificant amount. I wouldn't call it exceedingly rare, maybe rare or unlikely, but nonetheless, not an insignificant number of defendants received a sentence of 2 years or less that were identically situated. At any rate, so here are the stats. Nationwide, 352 identically situated cases. Average was 76 months, median was 72 months, and we see the range here. Interestingly enough, in D.C. Circuit and District of Columbia here, kind of redundant as we know, as they're coterminous. At any rate, there were 5 cases between 2006 and 2016 that had this identical offense level, and the average sentence was only 14 months and the median was 0. So this will obviously would require further research. My guess, and this is just a guess, is that this case involving 5 individuals was probably a conspiracy, and all 5 were sentenced at the same time. And there was some extreme mitigating factor here where just about all of them got very low sentences, such as probation, with the maximum being 72 months. So somebody, probably the ringleader in that conspiracy, got 72 months and everybody got a lot less. So at any rate, setting that aside, the more meaningful number for Mr. Manafort to look at, of course, isn't these 5 spread over 11 years, which may have just involved one case as it were, but to look at these 352, because again, what's important about statistics and what the circuit courts of appeal have consistently said is that when you're analyzing sentencing statistics, you must do it nationwide. This isn't necessary. It's not. You can look at district statistics and circuit statistics and co-defendants, what they received, but at the end of the day, what 3553A6 really is concerned about with respect to unwarranted sentencing disparity is national statistics. So that's why we should always start with the national statistics here, and that's why we provide all iterations. At any rate, so looking there, 352, so 76 months, as we're going to see, still isn't very helpful to him. Now, if we drill down a little bit, we look at the trends here, the average sentences for this group of offenders. We could see it's gone down recently since 2014. It's a little bit less than the cumulative average. These are cumulatives, where these 352 cases we're looking at all of them from 2006 to 2016, but here on this graph we're going year by year, as you can see, and last year it was only 71 months, so slightly less than the 76-month average. So there's some helpful trends going on there. This is more really what he's going to be most interested in, or his counsel is the rate of government-sponsored downward departures. And as we discussed last time, what this is under 5K 1.1, the government and only the government can move for a sentence below the guideline range as a result of the defendant's cooperation. The court actually does not have the discretion to depart below the guidelines based upon a defendant's cooperation with the government, unless the government moves for it. So the government must move. The good thing for Mr. Manafort, not surprisingly here, and I think this is fully expected by all parties and observers of this case, is the government frequently moves for downward departures. And for identically situated defendants, as Mr. Manafort, they did so, at least last year, almost 2/3 of the time, 62.5%. So they are very liberal, I would say. The government is very liberal in these types of cases, moving for downward departures. I would fully expect, and I think the government wants this in this case, is for Manafort to cooperate. So if he does cooperate, what can he expect? Well, a pretty significant downward, pretty significant downward departure here. As we can see, they were a little bit more generous in 2015, but in 2016, the courts in the D.C. In the district court for the District of Columbia, on average, they departed 56 months, or almost 5 years off the bottom of the guideline range. So that's going to get him more or less around to 52 months, if I'm doing the math correctly in my head. If he gets a downward departure and if the government moves for it and he gets an average downward departure, he can expect a sentence, statistically speaking, of about 52 months. But that, in and of itself, still may not be helpful to him. It may give him a little bit of light at the end of his sentence, but not much. And here is why. And this is something that certainly anybody looking at a federal sentence, I'd say that's over 40, and certainly their attorneys should be considering too, and that's life expectancy. So if we hop on here to the Social Security website, they have a really handy-dandy life expectancy calculator. There are more sophisticated ways to estimate life expectancy, of course, but here this gives you a quick and easy rule of thumb. So for a male, 68.7 years of age, which is what Manafort is right now, and certainly will be by the time of his sentencing, should that occur, his additional life expectancy is 16.4 years. In other words, he's expected right now to live to be about 85 years old. But you can't just look at that and say, well, if he gets a sentence, let's say, of 52 months, which is about 4 years and 4 months, well, he still has a lot of time left. He's going to have over 10 years. Not so fast. Recently, a researcher published this really interesting article in the American Journal of Public Health. If you're interested in the citation, I'd be happy to send it to you, or a copy of the article. Just send us an email or post your interest on the YouTube channel, and we'll respond. But what this researcher had done is she looked at New York sentencing data, inmate data and sentencing data. And what she discovered, what I've highlighted here, is that for each year of time served in prison, a person could expect their life expectancy to be reduced by 2 years. And I actually spoke to the researcher, and what she had not accounted for, this was basically overall, actually the typical age of the defendant or the inmate that she was looking at when she did this analysis. They were in their 30s. So I asked her, well, what about people who are older, 40s, 50s, 60s? Would the decrease in life expectancy increase? Because one would think that prison is is not a good experience for anybody, even in camps or minimum security facilities. But for older inmates, of course, one would intuitively think that the deleterious effects of incarceration would increase and be worse. She hadn't studied for that. Some research that she's interested and may do in the future. But so at the very least, what we know is it's going to reduce life expectancy by 2 years. My intuition, though, is that for older inmates, it's going to be even greater. But nonetheless, this is startling, and you'll see why here. Because if we plug in Manafort's age, the blue line here is his age, starting at year 0, his first year of sentence. And I've computed this out for 9 years, which would be 108 months, the bottom of his guideline range. So just assuming he got a guideline sentence, the bottom of the guideline sentence, which I don't expect he will, even if he's convicted at trial. But nonetheless, looking at this, we see here his life expectancy, as we said, starts about at 85 years. Right now, he's expected to live to be age 85. We can see where it intersects here, basically around year 5. So what this indicates to me are about 5.5, really, technically. Any sentence 5.5 years or greater is a de facto life sentence for Mr. Manafort, statistically speaking. So, as we indicated, with a downward departure for cooperation, if he receives the average, he can expect a sentence of around 48 months. That's going to put him right about here. That still does not leave a lot of room for life. essentially, that if he was to serve the full 4 years, which he won't, he will only have a few years left. But nonetheless, that gives him something. Now, of course, what we haven't factored into this equation is good time conduct. Federal inmates get approximately 15% off their sentence, so that's not factored into this. Nor is the fact that very often the Bureau of Prisons will do an early or have an early release program where inmates generally serve the last 6 months of their sentence under either home confinement or at a community corrections center. And given his advanced age, and if he was to have any other medical problems, there are also other programs in place for what's called compassionate release that he may be eligible for. But all those are obviously assumptions, given the just statistically speaking, and not assuming any good conduct credit, etc. He can expect that any sentence 5.5 years or greater is a life sentence. So the point simply is his attorneys may be able to use this in negotiations with the government for a meaningful downward departure. Yes, their downward departure may be greater than average, and necessarily so, because if it's not going to get him maybe a couple of years in prison, if it's not going to result in a downward departure to, say, for example, 24 months, then he's really not getting any benefit out of this, and he may as well just go to trial and roll the dice there. So at any rate, this concludes this week's review of the Manafort sentencing. Of course, we anticipate returning to this quite frequently as the case progresses, and we do really appreciate viewer feedback. And again, any errors or omissions, please do let us know about that. That certainly helps make our presentations not only accurate, but more meaningful, and hopefully help with counsel in their advocacy for their clients. Thank you very much.